Injuria. Definition. In law, a violation of rights, a wrong of such nature that the law wi.ll take cognizance of it. Kinds of injuria. Basically two kinds of injuria. 1. Damnum sine injuria. 2. Injuria sine damno. Valenti non fit injuria. Ubi jus, ibi remedium. 1. Damnum sine injuria. Meaning. This maxim means, damage without infringement of any legal right. By damnum is meant damage in the substantial sense of money, loss of comfort, service, health, or the like. By injuria is meant a tortious act, it need not be willful and/or malicious, for through it be accidental, if it is tortious, an action will lie. Where there is no infringement of a legal right, the mere fact of harm or loss resulting from an act or omission will not render such act or omission wrongful even though the loss is substantial, and even irreparable. Damage thus suffered in the absence of the violation of any legal right is known as damnum sine, or absec injuria. A person liable in law there must, therefore, be present the element of injuria. Damage without injury, damnum sine injuria, is not actionable. There are many acts which though harmful are not wrongful and therefore give rise to no right of action in favor of the person who sustains the harm. In cases of damnum sine injuria, i.e., actual and substantial loss without infringement of any legal right, no action lies. Mere loss in money or money's worth does not, of itself, constitute legal damage. The most terrible harm be inflicted by one man on another without legal redress being obtainable. There are many acts which, though harmful, are not wrongful and give no right of action. Pakistan law, the same rule is followed in Pakistan. Illustration, Gloucester Grammar School case. The defendant, a schoolmaster, set up a rival school next door to the plaintiff with the result that the boys from the plaintiff's school flocked to defendants. Plaintiff sued the defendant for the loss. It was held that no suit could lie on the ground that bona fide competition can afford no ground of action, whatever damage it may cause. It is to be remembered that free and fair competition is allowed. But a competition in which legal rights of a rival are infringed is a ground of action. Thus, an action lies against a person causing injury to another by illegal interfering with the latter's trade, business, or employment. 2. Injuria sine damnum, or damno. This maxim means, whenever there is an invasion of a legal right, the person in whom the right is vested is entitled to bring an action and may recover damages, although he has suffered no actual damage. This maxim is just the reverse of the damnum sine injuria. Where a tort is actionable although he has suffered no damage, it is a case of injuria sine damno, i.e., infringement of legal right without damage. Actual perceptible damage is not, therefore, indispensable to the foundation of an action. It is sufficient to show the violation of a legal right, in which case the law will presume damage. Thus in cases of assault, battery, false imprisonment, trespass on land, etc. The mere wrongful act is actionable without proof of special damage, for, by the law of England, every invasion of private property, be it howsoever minute, is a trespass, though the damage be nothing. Illustration, Marsett v. Williams. A banker, having sufficient funds in his hands belonging to a customer, refused to honor his check. Although the customer suffered no damage or loss, the court held he was entitled to damages. The decision is correct. Result. The result of the two maxims is, that there are moral wrongs for which the law gives no legal remedy though they cause great loss or detriment, and on the other hand, there are legal wrongs for which the law does give a legal remedy, though there be only violation of a private right, without actual loss or detriment in the particular case.